Hello and welcome to the Legal Issues class. In this presentation, I will cover legal issues as they pertain to the people we support. The chapters contained in this module include normalization and social role valorization, human and legal rights, rights of individuals with disabilities, justice planning, advocacy, abuse, neglect, and exploitation, and guardianship and alternatives to guardianship. Typically, the concept of normalization refers to a process that makes something more regular or normal. The normalization principle was established to make patterns and conditions of everyday life that are as close as possible to the norms and patterns of the mainstream of society available to people with disabilities. Normalization includes the normal rhythm of the day, week, and year, a home to live in that should be normal in size in a residential area, the opportunity to attend school or work, opportunities for leisure time and social interaction, and normal developmental experiences of the life cycle, which include infancy, childhood, adolescence, and adulthood. Normalization serves as a guide for professionals in human services. It is important to understand that decisions and acts based on the principle of normalization are almost always correct. In 1983, the term social role valorization, or SRV, replaced the term principle of normalization and maintains that when negative definitions are placed on people, the people become devalued. SRV was established by Wolfensberger and may prevent devaluation and mistreatment in the eyes of the observer by eliminating differences that cause a person to be devalued. Changes in people's perception decrease devaluation. There are important factors that can change people's perceptions. One is physical integration, which includes people with disabilities living in residences that are in the same place as residences of people without disabilities. Another is social integration, which provides opportunities for people with disabilities to interact with all types of people in places that are open to everyone, like churches, malls, places for employment, and recreational facilities, among others. Lastly, age-appropriate environments like clothing, activities, and employment that match the age of the person contribute to social role valorization. In 1948, the Universal Declaration of Human Rights was established by the United Nations and was based on the belief that all human beings are born free and equal in dignity and rights, that everyone possesses the same rights regardless of gender, race, religion, cultural, or ethnic background, and that all human beings have the right to live, the right to self-determination, and the right to be free from slavery and torture. These rights are reflected in the U.S. Constitution. According to Wolfensberger, underlying principles of the Universal Declaration of Human Rights include all persons have full and equal rights. Rights may only be restricted through law. Laws may not discriminate except for legally relevant reasons. Procedures for restricting rights must observe minimal fairness requirements, and laws, practices, and means should be available to promote the exercise of rights. Legal rights are enforced as law and include two types: constitutional and statutory. Constitutional rights are established through the U.S. Constitution and the state constitutions. Statutory rights are established legislatively through laws, codes, and administrative rules set forth by the state and federal branches of the government. The excerpt on the application of legal rights from the Legal Rights Module book reads, "Historically, people with developmental disabilities have been treated inhumanely. During the 1950s and the 1960s, conditions for individuals with disabilities were terrible. Most people who had physical or intellectual disabilities were institutionalized, generally without due process and often against their will. Basically, they didn't have an option even if they had good support at home or in their communities. Many institutions were overcrowded and understaffed. Only custodial care was provided. There was not any type of job training or education. Nothing was done to improve their quality of life. In many cases, individuals with disabilities experienced inhumane and abusive treatment. It's difficult to comprehend how people lived from day to day in such poor conditions. People's rights were restricted, and they were not treated the same as other citizens. People with disabilities have the same human and legal rights as every other citizen. All people have the right to equal protection under the law. All people have the right to due process, where no rights may be withheld without proof that such action is necessary. If rights need to be restricted, they will be restricted in the least intrusive manner possible. The Health Insurance Portability and Accountability Act, also known as HIPAA, was established in 1996 to protect the privacy of medical records and personal health information for all Americans. HIPAA gives people the ability to find out how their personal information may be used. It allowed people to learn about any releases of their information that may have occurred. It limits the release of information to the least extent. It establishes the right for all people to obtain copies of their own health records and request corrections. And it grants people the power to control how their records are used and or released. HIPAA does not apply only to medical facilities, and as DSPs and professionals that work with people we support, we must follow HIPAA guidelines at all times. Employees of Red River Human Services Foundation are legally responsible to protect the health and information of people we support. Likewise, our agency must adhere to regulations that dictate how information is stored and shared. For example, records protected by HIPAA must be stored in a secure area. All agencies were required to transition to HIPAA policies and procedures in 2003. Additionally, all staff must be trained upon hire and annually on HIPAA policies and procedures. In order to maintain HIPAA compliance, employees should not reveal any information to people outside of the agency. They can tell people that they work with people with disabilities, but they should not talk about specific individuals, even if they don't use their name. Employees should know which records they are authorized to access, and employees should not talk within the agency to any other employees about a person beyond what is needed to carry out job functions. Employees should not talk about a person we support when everyone present does not need to know the information being discussed. As a staff member, you should follow these guidelines to ensure you are adhering to HIPAA policies and procedures while at work. Safeguard records and do not use them where others can read them. Try to review records in private. When not in use, store records in a designated secure area. Never share your computer password with anyone, and close all applications that access private health information when stepping away from a computer. When you send a fax with private health information, be sure the person receiving the fax is ready to accept it immediately on the other end, and always include a cover page. Follow agency policies and procedures on how to disclose personal health information. Follow agency policies for reporting violations of the privacy rights of a person we support. If you are unsure of whether information can be shared, ask your supervisor or agency administrator before releasing any information. In 1990, Congress approved the Americans with Disabilities Act, which gives civil rights protection to people with disabilities in private sector employment, all public services, public accommodations, transportation, and telecommunications. Agencies should assist and advocate for people we support to ensure they have the opportunity to learn about and exercise their rights. Specific components of the Americans with Disabilities Act address employment, public transportation and accommodations, and state and local governments. In regard to employment, employers with 15 or more employees may not refuse to hire or promote a person with a disability because of the person's disability when that person is qualified to perform the job. Additionally, the employer must make reasonable accommodations for the person with a disability if the accommodation will allow the person to perform the essential functions of the job. New vehicles purchased by public transit authorities must be accessible to people with disabilities. Public accommodations such as hotels, restaurants, dry cleaners, grocery stores, school parks, among others, cannot refuse people with disabilities. State and local governments cannot discriminate against qualified individuals with disabilities. In 1904, as an amendment to the North Dakota Constitution, the Grafton State School was established to provide protection and residential services to people with disabilities and was the only alternative at the time outside of a person's home. Although the amendment was created with good intentions, it eventually resulted in people living in inhumane conditions with overcrowding and staff shortages. By 1966, the Grafton State School and its Sand Haven subdivision housed approximately 1,400 residents. North Dakota had institutionalized more people per capita than any other state by the late 1970s, with the least amount of funding, resulting in the Arc of North Dakota versus the Governor of North Dakota and others lawsuit of 1980. The lawsuit was filed by the Arc of the United States and the parents of 6 Grafton and Sand Haven residents, alleging the constitutionally protected rights of people residing in the Grafton State School and Sand Haven subdivision had been violated. The lawsuit cited inadequacies in services to the state's citizens that were institutionalized at the Grafton State School and its Sand Haven subdivision. The lawsuit established deinstitutionalization and development of community services throughout North Dakota and established the North Dakota Protection and Advocacy Project, or P&A, which ensures the human, civil, and legal rights of people with disabilities. The following excerpt from the Prairie Public Broadcasting film, I Am a Person, provides a brief history of the lawsuit, including an overview of some of the conditions people were subjected to at the Grafton State School and Sand Haven, as well as interviews with former residents.
This is my friend.
Today, there are still some people who will look at people with disabilities as being somebody less, and that's a mistake.
I'm a person.
They're just like you, and they're just like me, and they have the same wants and needs and desires and likes as anybody else.
I am a person.
They might be cognitively impaired, or they might have a physical disability, but that doesn't make them a whole lot different than you.
I am a person, yes.
I am a person.
I am a person.
I am a person. We got it.
Production funding for this program is provided by the North Dakota Association of Community Providers through a grant from the North Dakota State Council on Developmental Disabilities and by the members of Prairie Public.
It's your day, like the balloon.
Every year, Roberta celebrates a very special anniversary, the day she was allowed to leave Grafton State School and begin her journey toward independent living.
January 12th was my big one, my 40th year out of the institution. I do not have many happy memories of living there. I had no choice, no rights, no chance of being the person I knew and believed I could be.
Roberta's graduation was the result of an early pilot program designed to help adults from the Grafton State School build more independent lives.
I think I was one of the first people that got out of Grafton. I was proud to be out.
Thanks to training and support services Roberta received in the pilot program, she rides the bus alone to her job every day, has the support to manage her own money, and is planning for a trip when she retires. Her life today is a far cry from what it had been.
How we like living up at Grafton. And I said, you don't want to live there. When we were at Grafton, we didn't have any privacy. We had to take a bath in front of the other kids. We ate our meals together. We went to bed early, get up early. It was so strict there. I didn't like it. Been out of there for 40 years. Not going back.
Although the state school at Grafton had been created in 1904 to provide short-term residential training, over the years it had become an institution where people with intellectual disabilities were isolated and locked away, many for life.
My first real experience with developmental disabilities was as a student at UND in a social work class. Our professor took us on a tour of the developmental center, and it left a lasting impression on my mind, and I think was formative in why I chose this career. I think what struck me the most when we were touring, in addition to seeing people in shackles and in various states of undress and lacking privacy, the lack of dignity and respect really struck me. Probably as much as anything, the lack of human contact. Walking through some of the wards, people would reach out and they would want to grab onto your hand. What I realized later was that it was so understaffed that people didn't have that kind of human contact. And so to have relationships, even fleeting, with people who came through was significant.
I always thought of it as the developmental center was this empty promise. They promise that we will help people with disabilities. We will train them. We will get them ready to go back to their local communities. And they never could fulfill that mission. They wanted to, but they couldn't because they never had the funding.
North Dakota had more people institutionalized per capita than any other state in the country, and we spent the least on them. So things needed to change.
In 1980, frustrated by the state's lack of progress, the advocacy group ARC of North Dakota, then known as the Association for Retarded Citizens, and 6 state school residents filed a federal class action lawsuit to force the state to improve the deplorable living conditions of roughly 1,400 individuals.
We went on what was called their public tour. So this was putting their best foot forward. And when we walked through the developmental center and they showed us what they showed to the public, we were offended. Everywhere you went, there was enforced idleness. Nobody was doing anything. Complete boredom. There were places that we saw on the public tour where there was urine and feces on the floor. The smell in the facility was horrible. And these, again, were their best places. With the benefit of the litigation, we were allowed to go everywhere where our clients lived. And once you saw the whole facility, you recognized that this is a problem that's going to be very, very difficult to fix.
Should we have done better? Yes. And should there have been more help? I agree. I think so, absolutely. But at the same time, I knew the administrators at Grafton. I knew so many of them working there. These were good people. And they were working with what they were provided in the way of funding. It's a very difficult situation. The state of North Dakota and the legislature, we did not do well enough. And we were trying to remedy that.
In 1982, federal judge Bruce Van Sickle took the matter out of the legislature's hands. His ruling forced the state to deinstitutionalize the residents of the state school and fund programs to support them in community-based settings.
At the time, we were moving a lot of people out of the developmental center. That was after the judge had ruled. There were timelines that numbers of people needed to be moved out by. And so it was, as you can imagine, during the 80s, a real active time of moving literally hundreds of people out of the developmental center. It was a welcome change in many people's eyes.
Instead of a single large state institution, a network of independent organizations in more than 30 communities across the state now provides housing, services, and support for people with developmental disabilities and their families.
We have opened doors with the lawsuit, but whether that's going to be meaningful for people with disabilities is up to our local communities and how well they accept people with disabilities. Today, there are still some people who will look at people with disabilities as being somebody less, and that's a mistake. You don't get to know the person, you don't get to know what their abilities are, you're just going to write them off because they look different or they act different. If we're all a little more accepting of our differences, that would make life better for everybody, including people with disabilities.
30 years after the ARC decision, the lives of people with developmental disabilities have improved tremendously. But there are some who still believe that people with intellectual and developmental disabilities can't hold jobs, learn new skills, have relationships, or be nothing but a burden to society. Those myths are being disproved every day. Laura was brought to Grafton during a time when it was believed people with disabilities could never be independent and should be locked up for their own protection. Today, she holds down 2 jobs and owns her own condo.
It's fun living in a condo so you don't have nobody to tell what to do, and you can do what you want. Feels good. Nobody to bug you.
Laura was 8 years old when she came to Grafton after her mother was unable to care for her at home.
And then she couldn't handle me no more. And then after that, she felt bad because she said, "Why I take her to the Grafton." She didn't know how Grafton was.
I didn't get to keep my watch and rings that meant so much to me. Family was forgotten and Dad's funeral was missed. Education was not for me because I was too good of a worker bee. The toilets didn't have the privacy we wished. Having clothes that fit was a lucky thing for me. Every time I asked to call my family, the answer was always no.
For Laura and many Grafton residents, living at the state school meant being hundreds of miles away from their families. It was difficult to remain in touch, let alone take part in her family's lives. When Laura lost her father, she wasn't even permitted to attend his funeral.
Felt sad, kind of scared, because she couldn't call nobody or kind of hurt.
After being allowed to leave the state school, Laura chose to move to a community near her family, and now she sees them often. Laura lives independently in her condo, but receives support from a community program which helps her with some tasks she can't manage on her own.
Cooking and paying bills or take me shopping, get some groceries or putting stuff. Such as nice people.
Okay, Gail, you're first.
Before the ARC
The ARC lawsuit has had major effects on the lives of people with developmental disabilities in North Dakota. It ensures the right to treatment and habilitation in the least restrictive, most normalized environment. It provides individualized team planning. It prohibits abuse, neglect, and exploitation. It ensures the right to education and medical therapeutic services. It mandates training for DSPs and other professionals. It provides case management, and it established the development of community services across North Dakota. There are some rights specific to people with disabilities that are mandated by the Council on Quality and Leadership, or CQL, Title 19, the North Dakota Bill of Rights, the United Nations Bill of Rights for the Disabled, and policies and procedures of state agencies. The rights are categorized into 4 areas, which are the right to appropriate, habilitative, and other services provided in the least restrictive, most integrative environment, the right to be treated with dignity and respect under all circumstances, the right to make informed choices and to control person and property, and the right to due process, including the protection of all human rights. It is important to remember that when we support a person to learn about their rights, we should also include the opportunity to exercise those rights. I will discuss the 4 rights areas over the next few slides. The right to appropriate habilitative treatment in the least restrictive environment includes, but is not limited to, receiving active treatment, which is the procedure and intervention designed to help people we support acquire greater mental, physical, and social development with the goal of achieving independence, high quality of life, job satisfaction, and satisfying personal relationships. Also included is freedom from cruel or unusual punishment, which ensures that people we support have the right to receive services in the least restrictive, most integrative setting. With this, if a person's rights need to be restricted, the process must be conducted so rights are restricted only as much as needed. Freedom from servitude ensures that people we support have the same rights as everyone and are free to make decisions about all aspects of their lives. Finally, people we support have the right to generic services and the right to receive all services to help them reach their full potential. The right to be treated with dignity and respect includes, but is not limited to, confidentiality of information, respect for privacy, freedom from cruel and unusual punishment, and protection of basic human dignity. When supporting people, there are things we should not do to ensure confidentiality is protected. We should not provide information about a person we support to anyone outside the agency without the individual or guardian's written consent. We should not discuss a person we support in a public place. We should not discuss people we support with other staff unless the information needs to be known to all staff involved with a conversation. And we should not engage in social media activities regarding individuals supported. Additionally, when working with people we support, we should partake in actions that provide dignity and respect. We should speak in even tones and not in loud, harsh tones. We should use positive words instead of negative words. We should discuss personal issues only in private and not in public. We should treat people with respect and not use threats or coercion. We should make eye contact when speaking with people we support. We should address people by their names and refrain from using nicknames. And we should provide a caring environment instead of acting in an impersonal manner. The right to make informed choices and control person and property includes informed consent. Informed consent is comprised of three components. The first is capacity, which is the ability to understand both positive and negative consequences of decisions. The second is information. The person must have sufficient information about the proposed choices. And the third is voluntary, where the person is free to decide without coercion, duress, threats, or undue influence from others. With informed consent, if it is legally determined that a person is unable to make an informed decision, a guardian is appointed to assist. Controlling person and property includes managing money and property, which can be exercised through learning budgeting skills and having access to stores and other places where a person can decide how to spend their money. People do not need to prove they have the ability to manage funds and property in order to partake in managing funds and property. Rights should only be restricted when all lesser restrictive alternatives have been attempted or considered. People have the right to freedom of religion and can choose which church and or religious activities they want to partake in. And people have freedom of free association, where they can choose who they spend time with. This also includes the right to receive and send mail unopened, to engage in social media use, to use the phone in private, to have guests, and to participate in social, religious, and community activities. Lastly, the right to due process ensures that all citizens have equal protection under the law. With due process, the opportunity to protest, to be heard, to be informed, to give consent, and to have a determination made by an impartial party are all included. For people we support, due process might include program plans, behavior management committees, human rights committees, and when required, the court system. Title 19 and the Council on Quality and Leadership both work to protect rights of people we support. Title 19 ensures that agencies protect the rights of all people supported. Title 19 is part of the Social Security Act for the Medicaid program and is executed by the Centers for Medicaid and Medicaid Services. The Council on Quality and Leadership provides accreditation to North Dakota developmental disabilities providers. CQL ensures the rights of people we support are protected by utilizing quality measures and factors to establish and measure outcomes. There are times when people with disabilities need assistance with the criminal justice system. In North Dakota, Individual Justice Planning, or IJP, has been established to assist in this area. For people with disabilities, IJP helps when a person's disability potentially restricts rights when the person is involved with the criminal justice system. IJP considers alternatives that are not part of the routine legal process in those situations. IJP has two purposes: to provide alternatives for the criminal justice system to consider, along with resources needed to initiate each alternative, and to provide a framework for the most appropriate services for people with disabilities. It includes services like education, communication between private and public human services agencies, among others. Before individual justice planning can be implemented, an assessment is required to determine what the person's challenging behaviors are and the reason why the person has the behaviors. IJP cannot be conducted without an assessment. There are times when people we support may benefit from utilizing the services of advocacy. Advocacy is an act or process of representing a person or group of people for the purpose of securing human and legal rights, to obtain needed services to which a person is entitled, and or to remove barriers towards meeting needs. People with disabilities benefit from advocacy, since minority groups, which include people with disabilities, are at greater risk of having their rights denied or violated. Once it is determined a person can benefit from advocacy, a written advocacy plan needs to be established. There are 4 types of advocacy. Self-advocacy is the process of representing one's own rights and interests. The intention is to empower individuals to speak on their own behalf and have ultimate control over their lives and any services they receive. Personal advocacy is the process of assisting or representing an individual in securing rights to which they are entitled. With personal advocacy, advocates perceive the needs and interests of the beneficiary separately from their own needs and interests, as well as those of third parties. Beneficiaries have a voluntary relationship with the advocate. The beneficiary must consent to receiving advocacy services. Advocates are independent of the developmental disabilities service delivery system and are free to focus on the needs and wishes of beneficiaries. And information about the beneficiary is confidential. Information about the person cannot be freely shared. With citizen advocacy, the goal is to meet the needs of people who are at risk of social isolation. It is a match between a competent community volunteer and a person with a disability to advance the best interest of the person with a disability. The goals of citizen advocacy are to provide companionship, to provide exposure to, and an involvement in normalizing experiences, to assist in solving problems of daily living, and to assist in accessing the local community. Systems advocacy is the process of influencing social and political systems in order to bring about changes in practices affecting a class or group of people who have developmental disabilities. Systems advocacy is commonly achieved through legislation, litigation, and education and training. Agencies in North Dakota are required to provide annual training for employees on abuse, neglect, and exploitation. The state of North Dakota has created definitions of abuse, neglect, and exploitation which relate to people who have disabilities. Within the definitions, the term caretaker, as defined by law, means a person, organization, association, or facility who has assumed legal responsibility or a contractual obligation for the care of a person with developmental disabilities or mental illness, or a parent, spouse, sibling, other relative, or person who has voluntarily assumed responsibility for the person's care. On the next few slides, I will review the definitions for abuse, neglect, and exploitation as they appear in the North Dakota Century Code 25-10.3-01. The definition of abuse includes willful use of offensive, abusive, or demeaning language by a caretaker that causes mental anguish of any person with developmental disabilities. Knowing, reckless, or intentional acts or failures to act which cause injury or death to a developmentally disabled or mentally ill person, or which place that person at risk of injury or death. Rape or sexual assault of a developmentally disabled or mentally ill person. Corporal punishment or striking of a developmentally disabled or mentally ill person. Unauthorized use or the use of excessive force and the placement of bodily restraints on a developmentally disabled or mentally ill person, and use of bodily or chemical restraints on a developmentally disabled or mentally ill person, which is not in compliance with federal or state laws and administrative regulations. Abuse can be verbal or physical. Verbal abuse includes speaking to a person with hurtful language, using insults, and making a person feel ashamed. It also includes using disrespectful language when discussing a person, like if you need to have a conversation about a person you support at work or not using confidentiality during those conversations. Abuse also includes punching, slapping, hitting, and kicking, but is not limited to those. Any unauthorized restraints, whether physical or chemical, are also forms of abuse. It is abuse to knowingly put someone in a dangerous situation where they are at risk of injury or death. The definition of neglect includes inability of a person with developmental disabilities or mental illness to provide food, shelter, clothing, health care, or services necessary to maintain the mental and physical health of that person. Failure by any caretaker of a person with developmental disabilities or mental illness to meet, either by commission or omission, any statutory obligation, court order, administrative rule or regulation, policy, procedure, or minimally accepted standard for care of persons with developmental disabilities or mental illness. Negligent act or omission by any caretaker which causes injury or death to a person with developmental disabilities or mental illness, or which places that person at risk of injury or death. Failure by any caretaker who is required by law or administrative rule to establish or carry out an appropriate individual program or treatment plan for a person with developmental disabilities or mental illness. Failure by any caretaker to provide adequate nutrition, clothing, or health care to a person with developmental disabilities or mental illness. Failure by any caretaker to provide a safe environment for a person with developmental disabilities or mental illness. And failure by any caretaker to maintain adequate numbers of appropriately trained staff at a facility providing care and services for a person with developmental disabilities or mental illness. Neglect is essentially failing to do what you are responsible for. Forms of neglect include not ensuring people we support have access to daily essentials like food, clothing, shelter, access to the community, and necessary medical appointments. Additionally, if we fail to keep our facilities safe, fail to adequately provide trained staff for people we support, and/or fail to follow through with legal responsibilities involving people we support, we are negligent as an agency. Staff can also be negligent if they fail to carry out a plan for a person we support. The definition of exploitation includes the taking or misuse of property or resources of a person with developmental disabilities or mental illness by means of undue influence, breach of trust, deception, harassment, criminal coercion, theft, or other unlawful or improper means. The use of the services of a person with developmental disabilities or mental illness without just compensation, or the use of a person with developmental disabilities or mental illness for the entertainment or sexual gratification of others under circumstances that cause degradation, humiliation, or mental anguish to the person with developmental disabilities or mental illness. Exploitation is when someone takes something that does not belong to them. It could be taking or borrowing items or money from a person we support. It could be a staff person conducting their personal business while at work or doing their own things on the time of people we support. Posting photos of people we support on social media without their permission could also be considered exploitation. People with disabilities are more susceptible to abuse, neglect, and exploitation and are 4 to 10 times more likely to be abused than people without disabilities. People with disabilities may be targeted for various reasons. Predators may view people with disabilities as weak and less likely to report abuse, neglect, or exploitation. It might be common for people with disabilities to be surrounded by small circles of friends and caregivers where someone in the small circle is the abuser. Many people with disabilities live in segregated communities like group homes where abuse can be more easily hidden and residents have limited access to police or outside resources. People with disabilities may have limited communication or cognitive abilities, which might make it difficult for them to report effectively. And people with disabilities may have low self-esteem as a result of verbal abuse and may believe they deserve being abused. Abuse, neglect, and exploitation can be prevented through ongoing staff training and development. Agencies with ongoing training on abuse, neglect, and exploitation were found to have 61% fewer instances. According to research, training can also lower DSP turnover, which positively affects the well-being of people we support. This list, which was developed by Markel and Trefaso in 2017 and appears in the Legal Issues module book, overviews warning signs of compassion fatigue and burnout, which can lead to a staff person becoming more likely to partake in abuse, neglect, or exploitation. Compassion fatigue is the depletion of empathy reserve that can arise from helping other people. It includes behaviors or symptoms such as feeling on edge and easy to startle, feeling hopeless as if nothing will ever go right, feeling angry or irritable without any obvious reason, not caring anymore, or feeling fed up, avoiding certain thoughts, feelings, situations, or activities because they remind you of a frightening experience, avoiding or ignoring people you help, feeling disconnected from others, losing sleep, and feeling drained. Burnout is a stress-related condition built up over a period of time by work-related factors such as high workload or feeling underappreciated. Behaviors or symptoms of burnout include feeling anxious or irritable, feeling depressed, feeling tired most days even after resting, losing sleep, difficulty concentrating, getting sick more often, changes in appetite, disconnecting from others, reduced work productivity, and just not caring anymore or feeling fed up. Things like working too many hours and not partaking in good self-care can lead to staff burnout. There are various fields like the medical, mental health, education, and law enforcement, among others, where employees are considered mandated reporters if suspected abuse, neglect, or exploitation are suspected. In our positions at Red River Human Services Foundation, we are all mandated reporters. That means we are legally required to report any instances where we suspect abuse, neglect, or exploitation has occurred. Specifically, the criteria for reporting is having knowledge of or reasonable cause to suspect that abuse, neglect, or exploitation is occurring or has occurred. As mandated reporters, if we fail to report, we are guilty of an infraction where the maximum penalty is $1,000. How do we report abuse, neglect, or exploitation? Reports must be submitted to the North Dakota Protection and Advocacy Project as soon as possible after the alleged incident has been brought to the attention or witnessed by staff. Reports can be taken over the phone, by email, or by written correspondence, although phone calls are the preferred method. Reporters can choose to report anonymously, but if at all possible, it is recommended to not report anonymously since it can complicate the investigation process. If reporters give their names are confidential and cannot be shared with anyone outside of the North Dakota Protection and Advocacy Project. Once a report is made, the investigation process is initiated. The twofold purpose of the investigation is to gather information in order to describe and explain an incident or an event, and to determine strategies that will decrease the potential of future recurrences of the incident happening. There are times when people we support utilize guardianship to assist them in areas where they might need extra support. A guardian serves as an advocate to protect the interests of the people we support who are not able to represent their own interests. When guardianship is in place, people we support are referred to as wards. A ward is a person who has a guardian appointed to them. Guardians are appointed by the courts and take on the decision-making of legal rights and make some decisions in the best interest of their wards. Guardianship should only be considered when a person is unable to make decisions for themselves, and the least intrusive level of guardianship is what legally should be established. Before guardianship is considered, other alternatives and service options should be tried. By North Dakota law, each established guardianship must be reviewed by the court every 5 years. In North Dakota, guardianship is legally appointed by the court and is not easy to obtain. It involves a complex process, including a hearing where considerations are made to determine the need for a guardian. Before a guardian can be appointed, the court must determine that the potential ward is incapacitated. Incapacitated refers to an adult person who is impaired by reason of mental deficiency, physical illness or disability, or chemical dependency to the extent that the person lacks capacity to make or communicate responsible decisions concerning that person's matter of residence, education, medical treatment, legal affairs, vocation, finance, or other matters, or which incapacity endangers the person's health or safety. If a guardian is appointed, there may be limitations to the guardianship. The guardian is granted powers only as outlined in the order. The ward should still be able to make as many decisions as possible. The guardian may be given no authority, limited authority, or general authority in the areas of residential, which refers to a place of residence, living arrangements, among others, educational, which refers to choice of education and training programs and services, medical, which refers to treatment decisions based on informed consent, legal, which refers to exercise and protection of legal rights, vocational, which refers to choice of employment opportunities and services, and financial, which refers to protection and use of property and money. When the court gives limited authority to a guardian in any of these areas, the court will specify the limits of the guardian's authority in that particular area. The ward retains authority that has not been given to the guardian. A person's person-centered planning team has specific responsibilities regarding guardianship. The team makes recommendations about the type of guardianship that is best for the person. The team is required to review the guardianship every year to ensure it meets the person's need. And the team should ensure the guardianship protects but does not deprive any rights the person is able to exercise. Guardianship may only be a temporary agreement. At some point, it may be determined that a person no longer needs guardianship. This chart from the Legal Issues module book shows various alternatives to guardianship. If there is concern about the individual's ability to make decisions and care for him or herself, less restrictive alternatives should be explored prior to considering guardianship. Alternatives include advising, where advice is provided regarding the risks, advantages, and consequences of proposed actions or procedures. The person can then make their own decision based on the advice. Teaching can occur in areas such as money management and independent living, and also with the skills needed to make decisions and manage independently. Advocating, where advocates serve as guides and advisors, is another alternative. Another is support services, like training and assistance that are provided by DSPs and other agency staff. And finally, emergency guardianship, where an emergency guardianship order may provide solutions to specific short-term emergency need to decision-making support, is another alternative. Supported decision-making is a new law established in North Dakota in 2019. It is a less restrictive alternative to guardianship and does not need involvement from the court system. With supported decision-making, the person makes their own decisions through being supported by another person who is selected by the person we support to ensure the person is well informed about potential decisions and outcomes. Supported decision-making has three components: the individual, the supporter, who is typically a trusted person like a friend, family member, or professional, and the supported decision-making agreement, which is made in writing that defines the type of assistance the person is requesting and what the supporter has permission to do. With supported decision-making, the supporter does not make decisions. The person supported makes the final decision. Thank you for joining the Legal Issues class. When you are ready, you can sign up for a time to take the test. If you have questions or need additional assistance, please email the training department at rrhsftraining@rrhsf.org. Thank you. The information contained in this presentation was provided by the authors of and derived from the Legal Issues and Developmental Disabilities Module Book.